I'm a lawyer and a researcher based at Elios Justice at Monash University's Law Faculty. This Zoom call alone is taking place in at least 5 countries that I know of. Being based in Australia myself, I wish to acknowledge the people of the Kulin Nations on whose unceded land that I'm speaking from today, and I pay my respects to their elders past, present, and emerging. I'm joined today by 3 experts in their respective fields. Valerie Khan, a gender justice and child protection specialist based at Great Dreams Consulting in Pakistan. Nitika Vishwanath, a criminal justice lawyer and researcher at Project 39 at the National Law University in Delhi, India. And Zamana Ashraf, a Bangladeshi human rights activist, the South Asia consultant of the Anti-Death Penalty Asia Network, and one of the co-authors on the report that we'll be discussing the findings of today. Their impressive biographies of all 3 panelists can be found on the conference website. Today's panel will start with a brief outline of the report that I co-authored with Zaman, Scott Walker, and Mai Sato, entitled A Deadly Distraction: Why the Death Penalty is Not the Answer to Rape in South Asia. This will be followed by a panel discussion on some of the themes and findings explored in the report, and then a question and answer session followed by our panelists' concluding remarks. I'm now going to share my screen so that you can see my slides. Okay. Can you see my slides now? Excellent. Our report. Thank you. Just my slides or my notes as well? I will share. So I will. Our report examined the 4 countries in South Asia that prescribe the death penalty in law for rape offences: Bangladesh, India, Pakistan, and Sri Lanka. Governments in these countries have introduced and/or expanded the availability of the death penalty for rape offences. While Sri Lanka appears to have, at least for the time being, resisted the urge to expand its capital rape law, broad advocacy against the death penalty remains largely absent. In focusing on the countries that have enacted laws prescribing the death penalty for rape offences, we excluded countries that sentence individuals to death for rape under uncodified laws, such as Sharia. Our research suggested that rather than attempting to control and prevent rape, governments have relied on penal populism, seeking to create the erroneous impression that they have prioritised the interests of victims in introducing and expanding the death penalty for rape. Behind the veneer that death penalty provides, our research reveals that governments are largely unwilling to do the hard work to address the patriarchal culture and the issues of power imbalance and inequality that perpetrate sexual violence. First, I will say something about the legislation in these countries. Bangladesh, India, and Pakistan and Sri Lanka each allow for the death penalty as an alternative to life imprisonment for rape in a number of circumstances. In Bangladesh, the law distinguishes between rape and gang rape, as well as rape and gang rape resulting in the death of the victim and rape followed by an attempted murder or harm to the victim. For all these crimes, the death penalty is a possible punishment. In India, the death penalty is available for rape where the victim has died or is in a persistent vegetative state. for rape in instances of repeat offending or where the victim is under 12 years old, for the aggravated penetrative sexual assault of children under 18 years old, and for gang rape where the victim is under 12 years old. Pakistan has the broadest provisions, with both rape and gang rape attracting the death penalty without any distinction in respect to the victim's age or degree of injury. Pakistan has also adopted gender-neutral language in the legislation and does not require a cisgender woman to be the victim of the crime of rape. By contrast, Sri Lanka has the narrowest provisions, where the death penalty applies only in instances of rape with the use of a firearm. Our research found that Sri Lanka was an outlier compared to the other three countries. While Sri Lanka has also had cause to publicly reckon with high-profile examples of sexual violence, these attacks have not been met with the widespread public calls for the expansion of the death penalty, nor has the government sought to do so. I want to briefly highlight now our key findings. We found that the claim that the death penalty deters rapists is yet to be empirically proved. We were unable to locate any research showing the deterrent effect of the death penalty for rape offences. We did note several instances, one in Sri Lanka and one in India, where harsher punishments for rape have been followed by a reduction in convictions. An important contextual element to note is that capital rape laws ignore the reality that most rapists are known to their victims, be it relatives, neighbours, friends and acquaintances. As one of our interviewees explained, quote, "People don't want to enter the criminal justice system and have someone they know being sent to the gallows." The picture painted of the criminal justice systems in Bangladesh, India, Pakistan and Sri Lanka revealed a number of commonalities with the integrity of the respective criminal justice systems. Whilst improving the flaws of the criminal justice system would certainly improve the experience for justice for victims, it should not be inferred that once these deficiencies are fixed, the death penalty could be an appropriate punishment for rape. Like many jurisdictions globally, there was a real reluctance to report rapes, linked to an overriding patriarchal culture, with victims stigmatised and non-reporting encouraged to preserve the family's honour. To differing extents, police handling of reports of rape were highly problematic in three ways. Firstly, there was a reluctance of or even refusal by police to take victims' reports. Secondly, there was an insensitivity towards the victim in the reporting process itself. And thirdly, many police investigations of rape allegations were observed to have been inadequate, often due to resourcing difficulties. Successful rape prosecutions often rely on strong forensic evidence. In all four jurisdictions, inadequate resourcing and insufficient training of forensic medical experts was noted. This results in secondary traumas for the victims, with one interviewee noting that this compounded the already deeply traumatic experience that the survivor has experienced through their assault. Assuming a case actually makes it to trial despite these hurdles, the process of giving evidence could be highly invasive and traumatic. Defence lawyers resort to misogynistic and victim-blaming rhetoric. We did note that legislative measures have been taken in some jurisdictions to address this, with victims being allowed to give evidence remotely and defence lawyers being restricted in what can be asked. In some countries, we've seen the development of specialist courts, with criminal justice actors receiving trauma-informed training. These reforms are welcome, but are in their early stages, and the extent of their implementation is not yet known. We detailed the existing programs and strategies that civil society organisations have developed to counter existing death penalty narratives. Very little has been done to combat pro-death penalty narratives directly. There was strong public opinion in the respective countries in support of the death penalty. Anti-death penalty activists have not been silent. Rather, there was a concern that this advocacy has resulted in a public backlash. There are valid reasons for not engaging directly with arguments against the death penalty for rape offences. However, not addressing the use of the death penalty for rape may result in more death sentences and executions, including in cases of wrongful conviction. Moreover, if unchallenged, governments may expand the use of the death penalty further by applying it to other social problems that they are unwilling to address. We propose that a victim-centred approach may find common ground with civil society organisations that currently endorse capital rape laws. We refer to existing campaigns that tackle sexual violence who use this language to improve support for victims and to restore their dignity. Indeed, challenging the death penalty is both compatible with and requires a victim-centred approach to addressing sexual violence. Using this lens, our recommendations focused on moving the conversation away from harsher punishment narratives and towards increasing public confidence in the capacity of their judicial systems to hold offenders to account. Summarising our 4 areas of recommendations in the report: 1, strengthening support for victims at every stage of their engagement with the criminal trial process. 2, reframing the existing narratives on sexual violence and issues of consent and gender-based violence through training and education. 3, engaging with a more holistic approach to victim support beyond the existing criminal justice system. And 4, building an effective network across civil society organisations and activists working on this issue, be it capital defence lawyers, gender-based violence advocates and child rights advocates, will be useful in challenging the current narratives that legitimise the death penalty for rape, building greater consistency and cohesion in advocacy strategies across the region. Finally, in response to sexual violence and the inadequacy of criminal justice responses to it, we hope that this report reiterates a simple but important point. The death penalty is not the answer. Indeed, it is nothing more than a deadly distraction from meaningful and effective reform. I will now turn to our panel and to commence our panel discussion. As I said earlier, we are very fortunate to be joined with 3 great panelists. I'm putting in the chat the link to the site that has their biographies so that you can see their backgrounds, but I might ask each panelist to briefly introduce themselves now, and then I'll turn to my first question. So Zaman, could I start with you?
Thank you very much, Sarah, and thank you very much who have joined from different parts of the world. It's a very early morning in Geneva, and very good to see all of you. My name is Zamana Ashraf. I am a individual member of ATPAN, Anti-Death Penalty Asia Network. And as a human rights activist, I have been working with the Asian Human Rights Commission and the Asian Legal Resource Center. Both organizations are under the same umbrella based in Hong Kong. I come from Bangladesh, but I cover the region as my capacity permits me to work as a main representative to the United Nations on behalf of the Asian Legal Resource Center. So right now, I'm just at the UN Human Rights Council to do some of my work. So yeah, looking forward to the meeting and listening to all of you. Thank you very much.
Thank you, Zaman. Natika?
Thanks, Sarah. Thank you for inviting me to be a part of this conversation. My name is Nitika Vishwanath. I am with Project 39A at National Law University, Delhi, which is a pro bono research and litigation center. One of our primary areas of work is the death penalty in India. Along with that, we also work on issues of mental health and criminal justice, sentencing, legal aid, forensics, and issues of custodial torture. I am a member of the Executive Steering Committee at Project 39A, and I also head the work on sentencing. And before Project 39A, I've also had a chance to represent pro bono survivors of sexual and domestic violence in India. I am a lawyer by training, but I've also been trained in gender studies, and my research interests sort of lie at the intersection of sexual violence and death penalty. So I'm very excited to have this conversation. Thank you.
Thank you, Natika. Valerie?
Hi, I'm Valerie. I've been living in Pakistan for 26 years. I'm French by nationality, and I am a consultant in gender and child justice. And I specialize in capacity building, and it's an honor to be with you all today.
Thank you so much. I'm going to start with Zaman. I will alternate the people who I've addressed the questions to, but every panelist will be able to answer. Zaman, starting with you, how has the political discourse in Bangladesh framed how sexual violence is seen in society?
Thank you very much, Sarah. The political discourse is very, very strange from the civil society perspective. We have definitely some of our best friends. They are the anti-death penalty campaigners, as you and my background shows that the key figure among them. And that's why I put him as the hero of justice. But at the same time, there are several others. But in the discussion among the civil society, many in recent years, they have publicly demanded death penalty and that has started from this trial against the 1971 war with Pakistan and Bangladesh, the independence period. So that was a big event that demanded a death penalty for the defendants. And there was a lot of questions about the judicial process guaranteeing the fair trial of the defendants. And now when we come to this particular research that we did about sexual violences, so there were demands for justice in general by many civil societies. At the same time, civil societies, they were very fine with death penalty that was added in 2020 with the amendment of the law against what is called Women and Children Repression Prevention Act. A law was adopted in 2000, and then it has got a few amendments. One of them was in 2020, and that came with death penalty for gang rape. Individual rape, sorry. It had the individual gang rape was already defined, penalized with death penalty. So, and when the government immediately, and there is a background that people, women particularly, was raped because they voted to some pro-opposition candidates. And the ruling party people, they were identified as the rapist. And they also, the rapist, they recorded video footage of sexually assaulting the woman. And then that was, they themselves posted in the social media. And that triggered outrage, public outrage and protest in public domain. People took to the streets and they started demanding justice. So what the government did immediately to control everything is very quickly, in just a week's time, amended the law and everybody went home. Some were okay with the changes among the civil society. And then some publicly said that we did not want a death penalty to be added for this. And this is a very shortcut, unnecessary change to the law. But at the same time, it doesn't come in conformity with the justice process and the kind of justice that the victims needed. So there is no holistic approach altogether in the system. Within the judiciary and outside the judiciary, Bangladesh has a one-stop crisis center to address the crimes or violence against women and children. But in the entire package, it doesn't address the problems altogether. And
Thank you.
there is just one thing is that the use of death penalty in it's not helping in any way. But okay, I'll come to that point if there are questions. So let me stop here. Thank you very much.
Thank you, Zaman. Sorry to cut you off before. Val, could you briefly talk about the political discourse in terms of Pakistan?
So the political discourse in Pakistan is a bit divided. If we look at politicians, largely, not all, but largely, it has to be contextualized in an environment where there was an increased, I don't know about prevalence, but reporting for sure of outraging cases of rape and sexual violence against women and girls and against non-binary people. And so that, and especially children, actually, and so it really created a public outcry demanding justice and also demanding effective action to actually counter this form of sexual violence, rape, especially rape. I think it needs also to be placed in a context where, and that's interesting, actually, the country has signed some international agreements and treaties. Pakistan avails the GSP Plus, which is a tax preferential system. And of course, ensuring that women are protected from violence is a significant component. So the answer, the political answer from the decision makers' perspective has largely been extremely populist. And that's when the momentum from I would say not only issuing and awarding death penalty, but also harsh punishment. So death penalty was there already in the legal framework in Pakistan, but it was reinforced with the latest legislation, which was, the anti-rape legislation 2021. In parallel to this very populist answer from the government or decision makers, to that public demand of justice and harsh punishment, there was also a divided answer from the civil society's side. Some women's rights groups are supporting death penalty to answer rape, and some feminist groups are not. And they're including within child rights group, there is also a clear divide. I just want to specify that whenever the accused in Pakistan is a child, then the death penalty in any case does not apply. The Juvenile Justice System Act forbids death penalty being awarded to any person under the age of 18. So it's a very, I would say, polarized and largely ill-informed political discourse, which claims that by issuing awarded death penalty, rape is going to be reduced. And we have seen that this is not the case.
Thank you, Val. Natika.
Thanks, Sarah. So in India, death penalty has existed forever, and the constitutionality of the death penalty was last challenged in 1980 in this 5-judge constitution bench of the Supreme Court called Bachchan Singh versus State of Punjab. And that's when the court last dismissed the challenge and said it was very much a constitutional punishment, but it sort of laid down a broad framework for judges to decide between life imprisonment and death penalty, because death penalty is an exceptional punishment under Indian law. So that's where the death penalty lies. But in terms of sexual violence and death penalty, all of it began with this gang rape incident on 16 December 2012, where a 23-year-old woman was gang raped on a moving bus, and she was very brutally physically assaulted, leading to her death after a couple of days. And that's when we saw protests across the country and young people. And historically, it was a pretty important moment because you saw everyone getting out on the streets and demanding the state to take action to prevent sexual violence and also to do something about it. I do want to at this point underscore that it is not the case that cases like these had not happened before. So what is very important to understand is that this case happened in the capital in New Delhi, in parts of Delhi where women like me who speak English, who occupy a certain class and social location were impacted, who have a voice. Dalit women, Muslim women in India have been raped, because rape in India is not just an assertion of patriarchal power, but also an assertion of your caste power, also an assertion of the fact that you come from the dominant religion. So I do want to underscore that there is a problem that we were angry only when a woman from a certain class was gang raped and murdered. And obviously the media had a very big role to play because this happened in New Delhi and there was a lot of reporting, and this got picked up by other news channels, by print media, and it became something very big. And that's when, though women's rights groups were not, and in India, women's rights groups, the women's movement has been fundamentally opposed to the death penalty, and that's been a really great thing. But when these protests sort of took over, all these voices got conflated, and ultimately it was the public demand to hang the rapists that sort of took precedence. And it was also a very easy solution for the state to offer, because there are multiple problems with criminal prosecution of sexual violence cases within the criminal justice system. But what we saw was the state set up a committee, which was headed by a former judge, Justice Verma Committee, to recommend reforms to rape law and also to recommend what can be done to address sexual violence. And that committee took a position against the death penalty and actually had great recommendations, which went beyond criminal law, because sexual violence is not something that can be solved by criminal law. In fact, criminal law, I don't think holds that kind of power. It requires a very fundamental social change. So one of the recommendations of the committee was, for instance, sexuality education in schools. But obviously, what we saw the government do was amend laws and just introduce harsher punishments, introducing the death penalty, including the death penalty for repeat sexual offenders, and also death penalty that led to death. So that was the first time that in 2013, we saw death penalty being introduced and for sexual violence. And subsequently, there were 2 cases of child rape and murder that led to a similar outrage. And that's when we saw death penalty being introduced for non-homicidal child rape. So now, and then there have been some more incidents of gang rape of adult women. And now some states have proposed and some states have in place death penalty for adult rape as well. So that's where the trajectory has been. And as I see it, we are just one incident away from another adult rape that gets media attention, and actually the death penalty being in place for all kinds of rape, non-homicidal rape. And I guess I can talk more about it later. I'll just stop here now.
Thank you, Natika. I might actually come back. I wanted to just ask you to expand on, you touched on the women's movement position in India, which I know is different to that in other countries that we looked at. So I was wondering if I could move to asking you, to expand on that, what has the positions of the women's movement been in terms of the harsher sentencing for sexual violence, and how have they engaged with the campaign?
Right. So I want to draw a distinction. While the women's movement has been unequivocally opposed to the death penalty for sexual violence and death penalty per se, it is not the same for harsher punishments. And I feel like in any conversation on the death penalty, we constantly need to also talk about life sentences without parole and remission, because those are the harshest punishments across the world globally. And that seems to be the solution, that we move away from the death penalty, but we forget that a lot of the critique or questions of completely doing away with goals of reform and rehabilitation in the prison system equally apply to life without parole. So in the women's movement in India, while one sees an unequivocal voice against the death penalty, that does not sort of spill over to life without parole. And I think partly it's a doing of the fact that the opposition of the death penalty is not really located in an understanding of punishments and sentencing. And it very much comes from a very philosophical understanding of death penalty being a very masculinist punishment, or death penalty giving the state the power to kill. And I think we need a fundamental shift in that gaze, in that understanding, and we really need to locate death penalty within the larger context of punishment and sexual violence, and talk about why or why not harsher punishments are a response to sexual violence.
Thank you, Nitika. Val, can I ask you, I guess, in contrast, in terms of Pakistan and a position of the women's movement?
So again, as I mentioned earlier, there is a divide within the women movement in Pakistan. Some of them actually believe that what is understood, the death penalty actually perpetuates toxic masculinity rather, and a patriarchal reading and definition of justice, which is often more taking place as revenge rather than justice. I think the feminist movement, and I'm thinking of groups like Aurat March, for example, or other organizations that are women-led, such as Justice Project Pakistan, for example, are aware and see it regularly of the I would say the dysfunctioning, that are related to forensic investigation, et cetera, and we need to remind ourselves that 85% of the death penalty being awarded in Pakistan are actually being commuted by the Supreme Court. So this tells you the level of problematic decision making linked to, again, investigation and prosecution challenges, attrition rate because of out of court settlements, and then apart from those criminal justice dysfunctioning, the fundamental philosophical question is, as Nitika put it, can we allow a state to kill? That again, it needs to be read also within the framework of the Islamic jurisprudence if we talk about Pakistan, and it's an interpretative challenge also, because as per Islamic jurisprudence, you always have other options but death if you want to. It seems that in certain cases those options are rather put aside by the I would say the populist political narrative. And death penalty is rather perceived by those feminist groups as an easy, I would say, luring into making people believe that the state brings them a solution. It's about luring people into believing that a solution has been found. The other group of feminists totally agree with death penalty. And so there is an ongoing debate within the civil society. However, again, at a political level and at a societal level, people largely support death penalty, especially in cases of rape. So I think it's interesting to see that the champions within the politicians and within the civil society are often women or youth groups who are basically, trying to propose alternative and use sciences also to say, we need to look at the journey, what brings sexual violence to happen, to occur. We need to tackle the root causes and not being easily and naively brought into the belief that death penalty is the answer to rape. I would say it's an evolving debate and dialogue, and the civil society and the women and child rights group play a crucial role into keeping that debate alive in Pakistan.
Thank you, Val. Zaman.
Sorry. Could you please repeat the question for me again?
Sure. The question is, what has been the women's movement position in Bangladesh in terms of this issue of the harsher penalties for sexual violence?
It's somehow, I mean, some of the feminist organizations, they are happy with the addition of the death penalty in the latest version. And also there are few who want a bigger change in the justice system, focusing on the issue that the matters related to justice regarding violence against women, including sexual abuses, are addressed holistically. So like Pakistan, there is also a debate. Some people think, I mean, if you look at the street protest, for example, hosted by many civil society groups, the first slogan is in Bangla, they call Fashi Chai. That means we want them to be hanged. So that kind of movement is there. And so people in the psyche of some group of people, that death penalty is a panacea for addressing any crime that happens, including rape and that sort of serious sexual abuses. But of course, there are very, few anti-death penalty campaigners among the female feminist organizations, and they're also trying to keep their voice raising publicly, and also in the internal discourse, if they have access to the system, particularly the government. But the other part, I should also say that Bangladesh has a very unique kind of government in terms of, if you look at the democratic standing and the legitimacy, then it's not there. So they hardly listen to anybody, whether they speak on merit or with research findings and very strong logics. So these things simply don't matter to the legislators or the government in the office at the moment.
Thank you, Zaman. Val, I'm going to start this next question with you. It was really interesting. The issues of how rates of conviction are recorded is complex, but what we can draw from the different amount of data recorded in different jurisdictions is that there are significantly low rates of convictions, particularly in Pakistan, Bangladesh, and Sri Lanka, as distinct in India, which had a significantly higher rate of conviction than the other countries comparatively. In the interviews for the report, there were these repeated themes of survivors not reporting because of the underlying impunity in the system, fear of social stigma, and fear of the really unfriendly criminal trial process. What's your view on how to address these low rates of conviction, taking into account that I'm sure we could just answer that question for the next 24 hours?
Okay, so I think what is important to say is that when you talk to justice actors, and that's why I make the difference between civil society and politicians, but when you talk to justice actors in Pakistan, largely they do not feel comfortable with the death penalty, actually. Okay, it's present in the legal framework, and they're sometimes bound by the law or they feel rather bound by the law to go ahead with it. But it's again, the justice actors do realize and acknowledge the impediments to a fair and transparent trial that are systemic, that are not personality led. We have problem with the investigation process, with forensic structures, and with all the social environment that you describe, stigma, whatever. So on one hand, ensuring, and that's what we've been saying also, the anti-death penalty activists, that by ensuring death penalty or extremely harsh punishment in cases of rape especially, you are actually contributing to the rule of silence, because we know that most of the perpetrators are people who are around the victim, close to the victim, whether family, colleagues, or community members. And so the repercussion or the social pressure that reporting a crime which may lead to that person being executed constitute is just unbelievable. So it's just adding to the victim's pressure and barriers to report and challenges rather than actually improving access to justice and providing justice. That's number one. Secondly, there have been efforts in Pakistan that were led by the judiciary, taken up now into the legal framework through the anti-rape legislation 2021, about establishing victim-centric procedures and structures even to allow a justice process, not only a trial, but a justice process that would actually avoid secondary victimization and secondary trauma as much as possible. However, this is still a work in progress. We have only to date 12 specific child courts in Pakistan, which are among the special courts that can try rape cases. Otherwise, the law allows also to do so for gender-based violence courts or juvenile courts. We lack, I would say, a structured system to ensure that those SOPs and that those specific structures are actually operationalized the way they should be. This is something that the state and the civil society is looking at together, including donors. And secondly, I think it has given path and space, and I guess the others will take that up, to other questioning such as, okay, apart from the justice process per se, in terms of focusing on, conviction, and we acknowledge that conviction rate is important to send a message saying this is not accepted. But the other aspect is, what about forensic mental health and addressing sexual violence in a far more holistic manner, on one hand at a societal level, and on the other hand at an institutional level, where maybe through reformative justice we could actually achieve a situation where there is justice on one hand, when the message is not violence is the answer to violence, and thirdly, where there could be eventually a society where simply sexual violence is being reduced. At least we don't think, and statistics show that killing people or keeping them in abusive detention environments stop them later on from relapsing and doing it again, and rather you may actually happen with even more disturbed and violent people. So these are the real questioning and evolving elements right now.
Thank you, Val. Natika.
Sarah, could you frame the question for me? Because
yes, I thought
how these other countries have a low rate of conviction compared to India. So it helps me, because otherwise I may go on and on for quite some time. And I want to have
I guess it's interesting, because I think that one way that the low rate of conviction was certainly referred to as one of the reasons why countries have moved to harsher punishment. That India has moved to harsher punishment with a rate of conviction around 27%, 30%, which is similar to many other countries, and also made the move to harsher punishment, which I guess I'm saying there's also the other issues of impunity, the court process, and other kind of reasons being why survivors are not engaging with the process, and reflecting on that.
Right. So while in comparison, India seems to have a high rate of conviction, but if you sort of look at what's the conversation in the country, it's very much that the rates of conviction are extremely low in rape cases. That is the logic, that is the underlying logic. But I think before going to conviction, I think what is important is for me to contextualize what the experience is like for someone who wants to enter the criminal justice system and prosecute their offender, their perpetrator, because while 27% is the rate of conviction, I guess what is also important to look at is that a lot of the trials in India, and this is not just a problem of rape trials, I just want to underscore that, it is a problem largely of criminal trials, that they're very long and drawn out, right? They take years sometimes. And so when you look at that context, and that's a doing of multiple things, infrastructure, resources of the court, and very many other things. And in that context, what one is seeing is the courts not just introducing harsher punishments, but also getting into the questions of, let's have shorter trials. Let's have rape trials be finished in 60 days. And that is not necessarily a good thing, because it's a system that actually cannot realistically wrap up a trial in that time. So when it tries to, there are major lapses in due process. So even though convictions may happen at trial courts, the chances of those converting into acquittals in the appellate court, in the High Court, Supreme Court would be high. So I just want to clarify that when we say high rate of conviction, we don't know the eventuality of these cases in the appellate court. In terms of the experience of the survivor, I think the biggest problem, and research in India documents this, that the biggest problem that rape survivors in India face is at the pre-trial and trial stages in navigating the system. And one of the first problems is, generally the social understanding of rape and it being connected to honor and shame. So even that decision to report is a big one. And more so in child sexual abuse cases where perpetrators are known persons. And then once your first encounter with that decision to sort of initiate or put criminal law into action is conversation with the police or going to file the complaint, and how the police are also very insensitive and not very encouraging, and often are of the opinion that, well, why do you want to go through this? And you will be re-traumatized and you will be asked to repeat what happened to you time and again. So that's a concern. The other concern is that the victim is almost treated, even once the complaint is lodged, the victim is treated like someone who's just, their body is just there to offer evidence for the case, almost forgetting the fact that this is a person who's gone through a violent experience and they need medical care and support. So even the way medical examination in these cases is carried out in India is of great concern, where doctors will either have preconceived notions about whether this is a fake or a real case, and also the way injuries will be dealt with. It is all about documenting it for it to be a medical legal certificate, but not really about paying attention to the needs of the victim. And while there is a lot of budget for what is called the one-stop rape crisis center, but a lot of these centers are actually not functional across the country. So, and then starts the thing of navigating the trials, right? Anyway, the language of the law is so exclusionary, and then for a survivor who does not understand the law to navigate the trial system, to completely be not informed of what's happening and what the processes are like. So I think in India, the main problem is at the reporting stage and then at the navigating stage, and also how this becomes an issue of the body of the victim being an evidence collection site, rather than acknowledging the fact that they need, that criminal justice is just one aspect, but what they also need is medical care and support.
Thank you. A holistic approach. Zaman, I'll ask you the question again. With Bangladesh, with the very low rates of conviction, people that we interviewed discussed the problems with people not wanting to engage with the system, particularly in Bangladesh, about they discussed about the impunity. I was wondering if you could share your thoughts on that.
Thank you very much. When we want to see a high rate of conviction, the qualitative conviction, then we need to have certain things in place. First of all, the victim-centered approach of the entire justice mechanism, and then you need to have the competence of the institutional setup and that should begin with the policing system and the forensic examination system. Then you, I mean, gradually, when the investigation part is done, then you need a good prosecutorial system, and then the adjudication system as a whole. When you look at Bangladesh, the beginning has, in every stage, there is a serious problem, because the competence cannot be, available because of highly political motivation in recruiting people. So instead of recruiting a very qualified officer, for example, or a social worker at this one-stop crisis center, somebody who has a connection with the ruling party, just having some academic degree, without the compassion, without the sincerity or the professional commitment to the job, just is getting recruited. So then these people are just to get the benefit of the system, as a job holder, but not to offer anything to the victims who are in need of a very comprehensive psychosomatic legal support from in the context. Then it also becomes a matter of the attitude of the institutions. Looking at the family background or the kind of influence a victim comes up with, that becomes, very significant in terms of whether she will get support consistently or not. If somebody without any stronger influence comes to the system, then you cannot expect that their cases will be properly recorded and then processed in each of the stages. So and then you have the sensitivity and the evidence from forensic and other circumstantial evidence properly collected. But what we see these days, that Bangladesh judiciary has turned to be a matrimonial agency. The alleged rapist is in jail for some time, and the provisions are harsh that they remain in jail without bail for a longer time. So the court orders at one point of time, there might be various kinds of dealings in the background, either political influence or, I don't know, corruption, bribery. Right now, I don't have proof, that's why I'm not saying it. But corruption is a very rampant in Bangladeshi judiciary system. But what we see, and there are plenty of media reports that I can cite, that judge, including High Court judge, is ordering that the victim should be married to the perpetrator, the rapist, and that kind of marriage is taking place in prison. And after the matrimonial formalities are done, then the perpetrator is granted bail. So, when we talk about the conviction, so in one hand, you need this the institutional strength and their what is called the motive or the commitment to uphold justice. Only conviction in whichever way is also not helping anybody, and to address the social crisis into that. And I think Nitika has covered some of that. In Bangladesh, this is a serious problem. Your prosecution, your investigation, crime investigation, if you check each of them, it's so faulty and so flawed that even many convictions are not sustained in the higher court because of this flawed criminal investigation and adjudication at the trial court. And then you have the other problem. And for conviction rate, there is another part, is this political impunity. So somebody, when the perpetrator is not a ruling party engaged or somebody's relative or cannot influence or the influential people from the ruling party, if they are not unable to or not going to intervene in a case, then the nature of the case will be toward one direction. But when this kind of intervention comes, then it doesn't go further. Then you get either the police will in investigation report say the allegation was not true. It was a conspiracy against the alleged perpetrator or the defendant. So it ends at the very early stage of investigation. But of course, by the time you also waste few years of going and coming to the court. So the fear in the people that if I go to the system, then I will be ending up with social stigmatization, re-traumatization, and then harassment and wastage of a huge amount of money and losing a profession that the person may have. Because if you go to court, your whole day is done. Early morning, you have to be there, taking the travel, and then you don't know that whether by evening you will be able to come home safely. So with all that, and in the process also involves a tremendous intimidation from the perpetrators and their allies. So there is a lot of issues without being addressed. I mean, just death penalty or harsher punishment that we have in place to address it all of a sudden.
Thank you, Zaman. I'm conscious of the time, and I would like to invite people to ask questions if they have questions. Otherwise, I've still got plenty more. The way to ask a question is to either post it in the chat, or you could use the raise hand function by clicking the reaction on your control bar and selecting raise hand. I'm also conscious that Zaman needs to leave to go on an aeroplane soon, so he will have to leave our session a bit earlier. So if you have questions about Bangladesh in particular, that please prioritize for before Zaman goes. Pathana, I can see that you have a question. Would you like to ask? Yeah, well,
เจ้าขออนุญาตถามได้บ่ฮัลโหลสวัสดีเจ้าขออนุญาตถามหน่อยนึงเนาะอันน่ะคือโทษประหารชีวิตนะกรณีอันน่ะล่วงละเมิดทางเพศโดยเฉพาะว่าเรื่องการข่มขืนคือสปป.ลาวเฮาบ่ได้กำหนดโทษถึงขั้นประหารชีวิตเนาะได้แลกเปลี่ยนนำมันนะหลายประเทศผู้บรรยายเพิ่นได้บรรยายมาก็รู้สึกว่าหลายประเทศเพิ่นก็วางโทษถึงอันนั้นขั้นประหารชีวิตเนาะแล้วข้าพเจ้าอยากขออันตั้งประเด็น2จุดคืออันที่1แม่นอันอยากฮู้ว่าเพิ่นมีวิธีการแนวใดเวลาผู้หญิงถูกข่มขืนหั่นน่ะแน่นอนว่าเขาเจ้าก็บ่ค่อยอยากเข้าถึงความยุติธรรมหั่นน่ะแล้วประเทศเพิ่นหั่นน่ะสิแม่นอินเดียบ่หรือว่าบังกลาเทศก็ได้อันอยู่ประเทศนึงให้เพิ่นอธิบายว่าเพิ่นมีวิธีการอันโฆษณาหรือว่าชวนเชื่อแนวใดเพื่อเฮ็ดให้ผู้หญิงหั่นน่ะดึงดูดผู้หญิงอยากให้ผู้หญิงให้เป็นอันนำคดีเข้าถึงกระบวนการยุติธรรมเนาะเพราะว่าอันนี้มันเป็นเรื่องที่ว่าน่าอายเด้เนาะส่วนหลายผู้หญิงถูกล่วงละเมิดแล้วก็บ่อยากให้ศาลตัดสินว่าซั่นซะและอันจุดที่2อันเว้าถึงวิธีการประหารชีวิตนะอยากฮู้ว่าทางบ้านเพิ่นหั่นการประหารชีวิตนี่เพิ่นได้เฮ็ดแบบเปิดเผยบ่หรือว่าได้เฮ็ดแบบปิดลับเพิ่นประหารด้วยวิธีใดเนาะอันยิงเป้าบ่หรือว่าแขวนคอบ่แล้วด้วยวิธีใดเนาะขอแลกเปลี่ยน2จุดนั้นเนาะขอบใจ
Thank you. Were the other panelists hearing the translation of that? Okay, so
I couldn't hear the translation actually.
So on the bottom you have to switch to English, But the question was around access to justice, how victims want access to justice, and so how can they go about having access to justice, in particularly in India and Bangladesh. And the second question of what are the methods of executions. So Zaman, I'll start with you before I let you go.
Thank you very much for the question. Very quickly, the answer about access to justice is the access to justice has to be free and without any harassment, any intimidation, and the accessibility should have the reputation, the judicial system, that this system is allowing anybody who is a victim of any crime, and particularly for rape, has a very smooth and unhampered access to the system. And then this system is not going to harass them. Instead, it is going to stand by them with compassion and with very much professional openness to help them, so that at the end of the very quick and transparent process, they will be afforded justice. So in all layers, I'm not going to explain that. And then the second thing is the question in Bangladesh, when the death penalty is executed, it's the death penalty award is given in a public trial. The court, the judiciary judges in open court, they declares that sentences, but the execution takes place in private facility, in jail particularly, and that ordinary people don't have access to that, but the information is communicated publicly. Media publishes report about that, such and such person is going to be executed tonight. It happened mostly in the middle of the night, between 10 to 2 o'clock, that type of, I don't know what is the logic behind that, but that is the time that they choose. And after that, the message also communicated with the media and other entities that it has been executed. Thank you very much for the question.
The method is hanging, yeah?
Hanging in Bangladesh, yes.
Thank you, Zaman. And if you need to go, we understand. We don't want you to miss your flight.
Yes, maybe 10 more minutes I will, and then while I pack up, I will keep logged on to listen to you, but I may not be able to respond to anything.
Thank you, Zaman. Natika, and then Val.
So in terms of improving access to justice for sexual violence survivors specifically, I think beyond even trying to make changes to the system, I think the biggest sort of hurdle to any kind of thinking on sexual violence in India and perhaps even South Asia is that it's in our public imagination, sexual violence is always something that happens on the street, and the perpetrator is always a stranger. So I think the biggest hurdle to access to justice is just our public imagination of sexual violence, which is why, at least in India, marital rape is not really a crime. In a lot of acquaintance rape cases, victims actually face a lot more problems. So if you are not someone who's resisted, who has injuries when you've been raped, the way the trial discourse goes on, it becomes very difficult to actually get not just the defense or the judge, but even prosecutors who are sort of defending you to believe that you've actually been raped. So I think that first I'd say is that kind of change that is required. And I guess that correlates to not just the society, but also what media is saying when it's talking about sexual violence. But in terms of entering the system, accessing the system, multiple things, and related to what I said earlier, sensitization of police, of doctors, not just the use of forensic evidence, but actually in India, even the collection of forensic evidence and storing forensic evidence is a very big concern. We don't even understand the science, and then we try and use it. And access to justice is not just a problem for victims in India, it's also a problem for the perpetrators. if you are someone who's powerful, then the system works for you. If you are a perpetrator or a victim who is marginalized, then the system does not work for you. And having seen the system myself from both the end of the victims and the perpetrators, I can say that with some level of credibility that, it does not work when you're weak, but it does tend to work when you're powerful. And I think that is the biggest problem, that your social location determines your experience in this system. So I think I think we need to zoom out and look at it in a more holistic way rather than just focusing on rape victims, because some of the problems are a larger problem of the system. But on rape victims specifically, I just want to add one more thing, which is the problem of witness protection programs in India, because like I said, sexual violence does not just happen in a patriarchal context. It also happens in a lot of communal violence. In India, it happens in a lot of caste violence context. And there, when the victims are not from the dominant group, you see a lot of pressure and intimidation on the victims. And ultimately, you will see that a lot of them will turn hostile or will just to drop out of the trial because there's that much intimidation. So I think we need some serious conversation on the witness protection program. That is something that has just not happened in India.
Thank you, Nitika. Just in terms of the method of execution, I understand would also be hanging.
Yes, yes.
Thank you. And Val, please share. I know this is a topic you've engaged with deeply.
So access to justice. So first of all, let's be done with that. Yes, we do hang people in Pakistan when we have to execute them, absolutely. But in terms of access to justice, again, I like to condone Nitika's statement that I think one of the key aspects of access in justice is actually realizing that criminal justice is not the only element into the overall justice process. All that social justice dimension and the preventive, the value of prevention related to sexual violence is an essential one. And interestingly enough, when you talk to judges or police or prosecutors, they tell you, we're going to try our best, but you need to do your work also and work on prevention and behavioral change and changing patriarchal norms. So they're very clear about that. Now, if we really stick to the justice process per se, starting from reporting the case to investigation, trial, and then post-trial dimension, we have a lot of commonalities with what Nitika has said, but I think what has been more significant for Pakistan is that there has been historical and unprecedented efforts to actually start addressing those questions. So the first one was the leadership, the police leadership at a national level. So within the provinces is first of all becoming increasingly aware of the fact that, they if they want to be looked at with credibility, they need to be more effective in addressing violence in general, I would say, but GBV and sexual violence in particular. And so one of there were two aspects of it. First of all, increasing the representation of women in the justice sector was a key element. And again, because of the, gender norms that characterize Pakistan, where you would need to talk or would feel far more apt or eager to report if there is a woman who's here to welcome you, number one. And for that, also ensuring that there are what they call gender sensitive structures within the police. So, it can be several concepts. It's a gender protection unit, which is a kind of police station which is coordinating with other stations where you have women who systematically, when there is a need to investigate or to take care of an FIR, would be there. You have gender desk, women desk, and increasingly women in the police are now being given, it's a tip in the iceberg, and it's still very nominal, but still leadership positions. So it also sends a message, number one. Secondly, you've had, and that's very much the spirit of the anti-rape legislation, I would say professionalization and, expertization of the justice professionals. You need specific police unit to deal with sexual violence. You need trained and specific judicial team to tackle this kind of forensic communication manage the environment. It's about physical transformation of the court, having special separate places, having video linkage, ensuring that there is also a kind of, playful and colorful environment for children who unfortunately have to be physically present in the court. And most importantly, ensuring that the victim does not directly meet the accused. That's those are measures that are there. And then I guess it's about, for example, ensuring that you have a support person, which will take, and be there for the victim from day one till the end, to support, to guide, to explain the process, because it's terrifying to go into a trial environment, a court environment, even a Thana, a station, police station. Access to legal aid. Pakistan has set up the Legal Aid Justice Authority, so that was important for it. And collaboration with with legal lawyers, appointment of special prosecutors who again have to be trained, have to protect the victim from secondary victimization, working on training of medical legal specialists. And I think the most important thing also is that all this is not only described in a legal framework, it's reaffirmed by legally binding jurisprudence coming from the apex court. So for example, you've had two major decisions, such as one banning the finger test, virginity test for victims of rape, which were very important. That was reinforced with legislation. Another Supreme Court decision outlawing the kind of, character assassination, which is currently taking place when you do such trial. And then reiterating, that's what also Supreme Court keeps on doing, as Nitika said, the right of the accused. We are not going to ensure access to justice to victims by denying the right of the accused. This is actually the best way to ensure that those victims are not going to get justice. So the notion of, fair trial is essential. And I guess it's about organizing a shift towards a behavioral change at a institutional and socio-cultural level, which acknowledges the fact that you need to be technical. In my view, the shift to be not only gender-sensitive perspective, but evidence-based perspective is critical. That's why this report was produced. And for example, bringing in neurosciences, forensic mental health, DNA forensic sciences is also essential. And when I'm saying forensic technicality, I'm also talking about forensic communication from the prosecutor, from the lawyers, from the judges as well, to actually work on a far more conducive justice environment for victims of rape.
Thank you so much. That but both Nitika and Val's answers really also spoke for action steps for the future, which I will come back to. I saw there were other questions. I don't know if the person who had their hand up wants to ask again. Yes, yes, please. Belanfang. I'm sorry if I've mispronounced your name. Please ask your question. Fail Amphan.
เจ้าข้าพเจ้าก็มีคำถามแลกเปลี่ยนกับบรรดาผู้ที่หลายบรรยายเนาะข้าพเจ้าจะมีคำถามอันที่หนึ่งคือการกำหนดโทษประหารชีวิตที่ว่าบางประเทศได้กำหนดไว้หั่นเนาะแม่นเฮ็ดให้การข่มขืนนี่ลดลงได้แท้บ่เนาะข้าพเจ้าได้มีการประเมินบ่มีการสำรวจบ่ว่าถ้ากฎหมายของบ้านค่อยกำหนดแบบนี้ว่าถ้ามีกรณีการข่มขืนนี้ค่อยต้องถึงขั้นมีการประหารชีวิตนี่นะฉะนั้นคำถามก็ขึ้นไปว่าเมื่อจัดตั้งปฏิบัติแล้วสิ่งดังกล่าวนั้นมันได้รับผลเท่าที่ควรบ่หรือว่ามันยังมีปรากฏการณ์เกี่ยวกับการข่มขืนนี่เพิ่มขึ้นอยู่ฉะนั้นทางออกตัวนี้ข้าพเจ้าคิดว่ามันใช้บ่ได้เนาะอันที่2มันมีคำถามที่2ข้าพเจ้าจะถามว่าเวลารับโทษประหารชีวิตแล้วนี่นะเนาะอยากถามว่าผู้หญิงที่ถูกข่มขืนนี่นะ ได้รับการสดเสยหรือว่าได้รับค่าตอบแทนค่าเสียหายที่มันเกิดขึ้นทันใดบ่เนาะเช่นว่าทางแพงนี่นะเนาะสดเสยค่าเสียหายทางด้านทางกายจิตใจของพระเจ้านี่นะก่อนจะมีการประหารชีวิตนะเราได้รับตัวนั้นบ่หรือว่าเมื่อมันมีปัญหาเกิดขึ้นแล้วเอาผู้กระทำผิดนี้ไปลงโทษก็คือการในข้าพเจ้าถามคือนั้นแต่ถ้าว่าบ่มีมันข้าพเจ้าอยากตั้งคำถามคืนว่าแล้วการให้ความยุติธรรมแก่ผู้ที่ได้รับความเสียหายนี่มันเป็นยังแท้จิตใจเขาเจ้ามันอยากได้ยังแท้ในการสดเสยค่ะในการที่ว่าให้ความเป็นธรรมนะเนาะให้ความยุติธรรมนี่นะนอกจากการวางโทษทางอาญาแล้วทางอื่นเด้เนาะอันนั้นอันที่2
Thank you.
อันที่3เรามานั่งฟังเห็นว่าบางประเทศที่บรรยายมันเห็นว่าการข่มขืนนี่มีหลายเกิดขึ้นหลายเนาะแล้วก็เป็นปัญหาที่แก้ยากพอสมควรฉะนั้นข้าพเจ้าจะถามว่ามันมีปัจจัยอันใดบ่ที่พาให้เกิดมีการข่มขืนอันนี้เป็นสิ่งที่ข้าพเจ้าอยากทดบทเรียนเนาะอยากเรียนรู้นะว่าปัจจัยทางด้านใดเช่นว่าฮิตของประเพณีนี่มันมีส่วนเกี่ยวข้องบ่วัฒนธรรมเนาะทางด้านสังคมอีหยังต่างๆมันมีส่วนบ่ที่พาให้เกิดมีการข่มขืนหรือว่าความทุกข์ยากหรือว่าการเข้าถึงการเรียนรู้ทางด้านเพศศึกษานี่อันนี้มันเป็นปัจจัยบรรดาพวกนี้มันพาให้เป็นปัจจัยบ่หรือว่ามันเป็นตัวอื่นซึ่งว่าอันนี้ข้าพเจ้าก็บ่ฮู้เนาะว่าบ่ฮู้รายละเอียดเรื่องสังคมเรื่องวัฒนธรรมในประเทศนั้นฉะนั้นเลยว่าสงสัยว่ามันเป็นหยังคือว่าเกิดขึ้นแบบนี้หลายแท้เนาะฉะนั้นเลยก็อยากเรียนรู้นำว่ามันย้อนอีหยังเพราะว่าบางประเทศคือข้าพเจ้าเคยได้ยินนี่เนาะว่าตัวอย่างเนาะประเทศอินเดียนี่เรื่องฮีตของการแต่งดอกนี่มันจะเป็นผู้หญิงไปโคบไฟสายเนาะฉะนั้นเฮาลองกลับมาส่วนว่ามันมีส่วนหรือว่าวัฒนธรรมทางด้านอื่นๆความเชื่อถือบ่เรื่องสังคมบ่สิเนาะบางเทื่อเฮาบ่คือกันแน่นอนหลายๆประเทศบ่คือกันฉะนั้นตัวนี้มันมีส่วนบ่ข้าพเจ้าคิดว่าการ
Thank you. That is
ตัวนี้
a lot of very complex questions, and I'm conscious that we only have 5 minutes. So, but we are in very good hands because Valerie and Natika are the people I would ask these questions to. And I'm happy that they are here to answer. But just so the first question was about whether or not rape is a deterrent. The death penalty is an effective deterrent for rape. I can certainly tell you that in our research we found zero evidence, no evidence that that the death penalty is an effective deterrent for rape. And I'm sure the others can speak further on this, but also just to remind Natika and Val, the other question was about compensation, I believe. How are victims compensated by the system if there isn't the death penalty? And again, a really complex angle of culture. How is death penalty? How is the sexual violence fed by underlying culture? So I don't know who wants to go first, but perhaps Natika. I'll hand it to you.
Sure. So I'll just take the compensation question first. There is a provision in the Indian law for payment of compensation to victims, which includes rape victims as well. It's section 357A of the Criminal Procedure Code. But very much like all other provisions where implementation becomes a concern, that even getting that compensation is a big hassle and, harassment for the victim. That is a very big concern. So what you see is that when there are cases of sexual violence, you only see the state being active when it has to amend the law and introduce new punishment or reduce rights of the accused or shorten the period of the trial. But actually, real things that will impact and make access to criminal justice for the victim better, none of that happens. And I do want to say, and I completely agree with Valerie, that because this conversation is specifically about criminal justice, but let's not be tied to that, because I mean, as someone who's seen criminal criminal legal system for 10 years, I have very little faith in the criminal justice system, and I don't know how I would choose. And I don't think there is a homogeneous conception of justice. And I mean, there's one research in India on what conceptions of justice look like for rape victims, but I feel like we need more conversations on it. So there's some conversation happening in India on restorative justice, especially in the context of child sexual abuse. But I think that is still not mainstream at all. So just for us to constantly be wary of criminal law and what it can or cannot do. And in terms of the larger culture, yes, that is a very big concern, which is why that gang rape on 16 December 2012 made us very angry. But when we see a woman being harassed in, say, a public vehicle, public transport system, like in a metro or in a bus, somehow that doesn't make us angry. So it's also about our selective rage, right? That why do, when women in our family are not treated equal to men, or when there's domestic violence within marriages, I mean, do we feel angry about that, or do we think that that's okay? And, you know, it's a spectrum. So I think unless we start confronting the everyday violence and what we think is not very serious, unless that starts making us angry and that starts bothering us, I don't think, you know, anything is going to change, because so much of it is entrenched in the popular culture, in what we watch, and the way we talk about things. So definitely, I mean, that needs to change. And that is such a fundamental reimagination of our society and, you know, how we function, that obviously it's going to take a lot, but I think that needs to be addressed if we need to have any conversation on gender-based violence. And I just want to also bring in one small thing that has been bothering me, is that when we're talking about sexual violence, in India, you see all the anger and rage only for stranger rape sexual violence. But for instance, you don't see the same rage when Dalit women are raped, when Muslim women are raped. You don't see that when sex workers are raped. That's not even a conversation that we are having. So I just want to sort of underscore that when we think of women, or when we think of people being raped, I guess we need to also broaden our understanding that sexual violence does not just affect one kind of women. And I'm forgetting if I'm missing out on something, Sarah, because I think I missed, or have I covered everything more or less?
I think you've covered that.
Okay.
Thank you, Natika. And Valerie.
Over to you, Valerie.
So yeah, as Sarah posted in the chat, so the Pakistani Code of Criminal Procedure also includes the possibility of giving compensation to victims of rape. It's increasingly used. It was not used that much before, actually. So that's a kind of new trend, an encouraging one, which is appearing. However, when we talk compensation, it's usually understood as a financial compensation. And I think there is also work to be done on you know, the social, and, you know, money cannot take care of everything. So I think we also need to look at how can you socially compensate or morally compensate a victim, given the toll and the price it takes to actually break the rule of silence and report. And again, compensation is extremely complicated when, again, we need to remember, as Natika said, that in our imagination is a stranger attacking a woman. Most of the case, those people are known to the victim. They are close community members or even family members, especially in the case of children. And so you know, you won't, how would you ask any financial compensation from a cousin or an uncle or a father, for example, right? When they may be your direct bread earners feeding your family. So it's a complex reality. And then as far as your very interesting question is, what feeds sexual violence? So first of all, I think we need to be honest and acknowledge that we do not know everything. We do not have all the answers. Why is sexual violence occurring is still a research topic. But what we know is that apart from structural challenges, you know, for example, where you have extremely patriarchal norms, where women have no freedom, over their body and their sexuality, where it's basically institutionalized the fact of controlling women's sexuality, where there is total taboo on sexuality. There is no life skills-based education to equip children, for example, to identify potential dangerous situation, have safe and ethical reporting channels that will actually lead to child-sensitive actions. We lack resource allocation, technical understanding of what sexual violence is and entails. We also have harmful traditional practices that actually support sexual violence. So on one hand, the entire country is shocked and wants sexual violence and rape to stop, but then we also have some, and including some religious leaders, and then we have other very conservative groups who would support child marriage. And we know that child marriage entails sexual intercourse with a child. You have harmful practices such as bacha bazi, which is a kind of, you can say, a boy who will dance and, you know, be your sexual companion, that are there. So if we really want to go into stopping and the root causes of sexual violence, apart from the norm that basically justify the fact of controlling women's body by men controlling women's body. Secondly, and again, there is an evolution, but a certain segment of society supporting child marriage, and that's increasingly not the case anymore. So that's good news. I think Pakistanis want to do away with that progressively, however, it's still there. And then I think the overall, and I'll finish there, you know, when we have an issue, and I guess it's a global trend as well, but that's for Pakistan, that's a reality. We tend to present violence as a response to an issue. And that means that we are actually promoting intergenerational cycle of violence that feed further, you know, violent and abusive behaviors later on. And so until and unless we don't address early child protection, for example, and change the normative gender framework and norms from the very beginning, we're not going to be able to tackle this intergenerational cycle of violence, which is feeding sexual violence as well. And then there are power dynamics, as Nitika said, that also feed this. And lastly, we urgently need to consider mental health as a priority intervention for public health and safety. In my view, these are, on one hand, the feeders of sexual violence, but then if you reverse the scenario, they also carry the solution or some solutions to counter it.
Thank you so much. I'm now going to bring this session to a close. I want to really thank our panelists, Valerie Khan, Nitika Vishwanath, and Zamana Ashraf, who are all so eloquent at any hour of the day, but particularly in your time zones now. I'm really grateful for your generosity of both your wisdom and expertise and your time in really amplifying this critical subject matter. On behalf of my panelists, I would like to thank the organisers of the Access to Justice Exchange, the people who have made this possible today, the hosts of the event, for creating this incredible virtual space so that we can share these ideas across the globe. And finally, I really want to thank everyone who has attended this session, being so generous with your time and sharing your thoughts. And if you have any feedback or want to engage further, I have put all our contact information in the chat. So thank you again for joining us, and we hope to continue this conversation in many ways. Thank you.
Thank you.
Okay, before we end the meeting, so I will share the magic words of these sessions is legal ethics. To make sure you all have the magic words to claim your e-certificate after the conference. Thank you.